Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Andrew Nissen, an Oregon construction lien law expert. Today's webinar topic is getting paid faster with liens, bonds, and contracts. So without further ado, I'd like to introduce the wonderful and fabulous Andrew Nissen.
Well, thanks. So my name is Andrew Nissen, and I'm an attorney here at Aldrich Goldstein in Portland. We do construction law, all types of construction law, including lien law, bond claims, that kind of stuff. So my goal today is to give you just an overview of how you can use those tools to secure your payment rights and hopefully get paid on your projects. If you have any questions, there's a chat box here on the right, and we'll do our best to answer questions at the end. Just to give you a review of our agenda for the day, I'll go over suggested change to your contract if you're a general contractor or supplier. Talk about how to secure your lien rights, and then a little bit about your bond rights for a public project, and then go over some lien and bond rules and exceptions, try to give you some lien law traps to avoid, and then finish with the right way to exchange a release for a check. Just a couple of things to watch out for when you're getting those releases that a project owner would like you to sign. So first, your construction contract, if you're a general contractor, especially if it's an owner-prepared form, it may include a prevailing party attorney fee provision, which looks like the little box in the middle. Prevailing party in any dispute, basically, if you win, the other side is going to pay your fees. So the typical rule, at least in American courts, is that each side pays their own way, regardless of who wins or loses, unless there's a statute, like a law, that gives fees to the prevailing party, or a contract provision that awards fees to the prevailing party. A lot of people think this is a good provision to have in their contracts, but I would say if you're a general, try to strike that. And the reason is that you are already entitled to get fees if you file a lien and you prevail on the lien action, so that the law gives you the right to fees as long as you check all the boxes. This provision here is more likely to benefit the owner a few years down the road if they decide to make some kind of defect claim against your company. Then this gives them the right to fees, where you want to be kind of done with the project and move on to other things. This can make kind of a small dispute all about attorney fees, which is, I guess, good for us, but not good for people that are actually out there working as contractors and looking forward to new projects. So it can really take a small dispute and blow it up. So that's why I'd say just strike it if you can. Securing your lien rights, this applies to private projects, both commercial buildings and residential construction. Basically, what is a construction lien? It was developed, 100 years ago at least, and it gives you a security interest in the property that you're working on. And the point is to preserve a contractor's right to get paid. So that if you do the work and the work is done properly, then you have the right to payment. And if the owner doesn't pay you, ultimately the remedy would be we call it a forced judicial sale of the property. That's very rare. It doesn't usually come down to that, but it's basically a powerful tool to preserve your payment rights. One thing to know about the lien law is that it's strictly construed. So that means things like your lien notices and your timing are critical. As long as you check those boxes, once you're kind of in the law of the lien, then you have a little bit more flexibility. But to actually get the lien and to preserve your right to be paid, you've got to check those boxes strictly, I guess there's really no better way to say it. If you start off by missing the lien deadline, then you got problems. And it's usually what I will tell people if they are obviously beyond the deadlines. I'll say just make a regular payment claim, go to court that way. Don't mess with the lien law because you're kind of at a disadvantage because those boxes haven't been checked in the beginning, and you'll end up just fighting about silly things. So goal is to check all the boxes early and start off on the right foot. So basically, make sure that you have the right to lien the type of project. It would be private construction projects only. You can't lien government land or government interests. However, that said, you could have a situation where like a private company leases land from the government at, say, a public airport. So you could lien potentially, depending on who the owner is, an interest in a hotel where the owner of the hotel leases the land from the government. You can still lien that private interest. The type of contractor that you need to either be a contractor or a supplier that provides labor, materials, equipment, or services that are actually incorporated in the construction of the improvement or the building. So if you've only done work off-site as a contractor, you likely do not have the right to lien unless that work has been actually incorporated in the project. So the example I'm thinking of is where someone does a bunch of preparatory work that doesn't actually make it to the site, and then they want to, because the project gets shut down, they may not actually have a lien right because that work hasn't been incorporated in the site yet. Moving on, you have to be able to check all the boxes with the Oregon CCB. So you're licensed, bonded, and insured. You don't have a lapse in your license so that you have the right to lien. You need to have a contract that meets the Oregon CCB requirements and also send your pre-lien notices where those are required. So for a residential project, a house or a smaller residential project, there are CCB consumer notices or notices of right to lien. There's a package that the Oregon CCB puts out, and I'll put the link in here, of basically 3 notices that you should do as a general contractor on any residential project. For a commercial project, if you're a subcontractor, you may need to provide what's called a notice of right to lien to owner. And I would say for a sub, your best practice is to just send a notice of right to lien on every job as soon as you start the work. And that way you don't have to worry about whether or not it was done on a particular project. You've got your notice of right to lien and you can point to it in your file. If it comes time to file a lien, you don't have to worry about that. So bond rights, this applies to public projects. So the kind of equivalent of a lien or something similar to a lien that gives you the right to be paid is a bond for a public project. So Oregon and federal law typically require the prime contractor to furnish a payment bond, and that way it ensures that the suppliers and subs down to certain tiers, up to at least for federal projects would be a second tier sub, has the right to make a claim on that bond if they're not getting paid. So for a federal project, typically that would apply to contracts of over $100,000. The prime contractor is going to need to apply or going to need to get a bond on the project. For an Oregon state project, similar dollar amount, but it's something different. There's the federal Miller Act, and then each state has something they call a Little Miller Act. Just a little bit different timing requirements. For a federal project, you need to provide written notice to the prime contractor of a bond claim within 90 days after the last date you performed labor or supplied material. It's kind of a timing requirement there. You don't want to be too early and you don't want to be too late. For the Oregon state projects, your timeline goes up to 180 days instead of 90 days. So the idea is if you're not getting paid on a federal project, you want to make sure that you're looking into these timeline issues and providing notice kind of well before your timing requirements. If 30 days have gone by and you haven't gotten paid, talk to an attorney and or go to a lien service and get your lien filed or your bond claim notice sent out, depending on what type of project you're on. So here's some rules and exceptions to know about for liens and bonds. A little bit more detail on this slide about your pre-lien notice requirements. The link to that, the 3-pack of residential construction notices is on the Oregon CCB website. So that's oregon.gov/CCB. And then just type in required notices. And there's a PDF with all 3 notices. You can print them off and attach them to your contracts. And again, if you're a sub or supplier, you want to provide a notice of right to lien for any residential project and for some commercial projects too. The way the law is written is a little strange, but it's basically, it protects work you've done from the date of the notice going forward, and it also reaches back 8 days. So the idea basically is once you start on the project, within a week, you want to provide that notice of right to lien, and it covers you for the previous 8 days. And then obviously it covers you going forward. So that's why I say as soon as you start work, you send your notice so you don't have to worry about whether you sent it or not. And you don't end up in a situation where only some of your work is covered under the notice of right to lien. You've got to file your lien within 75 days of the earlier of when you stopped working, the date you ceased to provide labor, equipment, or materials, or 75 days after completion of construction. So it's the earlier of those. If you're a subcontractor, your date is probably going to be the last day that you provided labor. If you're a general contractor, it may be 75 days after completion of construction because the GC tends to be on the project for the entire time. Under the law, completion of construction has a special definition. I just want to go over the 3 different ways it can happen. If you want more information, you can look at the statute I cite there. But basically, substantial completion of the project, or there's a valid completion notice posted on the project. You would know that because you go to the project and the owner has posted the completion notice on the front door. Or the improvement is abandoned under the law. So that's a project that basically stops in the middle. Within 75 days of the abandonment, you need to file your lien to protect your right to get paid. The law contains different requirements about what the lien itself needs to contain. Basically, the way the text reads, it says a true statement of demand after deducting all credits and offsets. So that's basically how much you think you are owed. Then you need to include the name of the owner, the people that employed you, a description of the property. But where I see people sometimes get hung up is when they make their statement of demand in the lien, they'll just put a total dollar amount. So what I suggest is providing a little more detail. Here's a sample statement of demand. We actually list out the contract price, change orders, any pending change orders, maybe things that are in dispute. Give a total value to the work, subtract your lien recording fees and costs and the amount you've been paid to date, and that's how you get to your lien amount. So that way somebody looking at it can say, okay, here, I understand how much they're asking for, a little bit about what it's based on. And then typically we'll attach an exhibit that breaks down your labor, materials, services, and equipment in different ways. So these charts here are examples of how we've seen people do this in the past, the different types of material or charges for those. Sometimes we'll list a summary of the invoices. And the reason to do this is to provide enough information so that the owner or whoever's looking at the lien can figure out what it's based on, kind of by asking simple questions. That's what one of the cases says. If the owner has enough information by asking simple questions to know what the lien is valid or not. After you file the lien, there's also post-claim notices. So once you have filed the lien, you've got 20 days to provide notice to the owner and to the mortgagee. So that's, if there's a loan on the project, you should be able to search the title records and find that out. You want to provide that notice within 20 days, via certified mail. And then before you file a foreclosure lawsuit, got to do that more than 10 days before you file a foreclosure lawsuit. A lot of places will combine the notice of lien filing and the notice of intent to foreclose into one document. So that way it's done, it's out of the way, and you've checked both of those boxes. So the foreclosure lawsuit needs to be filed within 120 days of filing the lien. So you got 75 days to file the lien. You have 120 days from there to actually file that foreclosure lawsuit. And again, that preserves your right basically to foreclose on the lien, force a sale of the property if it comes to that. Got a note here regarding arbitration agreements. A lot of contracts require arbitration. So you'd want to talk to an attorney about what to do in that situation. Sometimes we will advise people to file both your lien foreclosure lawsuit and an arbitration at the same time, and then you basically work with the other side to put the foreclosure lawsuit on hold and resolve your claims that are required to be arbitrated per the party's contract or other agreement, and then you get back to the foreclosure lawsuit. It's kind of a placeholder until that arbitration is done. For bond claims, already covered this, but just be aware of the timing requirements. 180 days for a state project that's using that Oregon Little Miller Act, and it would be a shorter time frame, 90 days for a federal project. Another source of payment people don't often talk about is the Oregon CCB bond claim. So that's if you have a subcontract, let's say you're a GC and you've got a subcontractor who has a bond on the project, and you want to make, if the subcontractor wants to make a claim against the general contractor, you can do that through a CCB bond. It's kind of a rare thing, but it definitely does happen. And a licensed contractor will have a year from completion of a structure to file a CCB claim against a contractor's bond. So the contractor to contractor claim, we've done it a few times, and sometimes we're able to get some recovery that way. Lien law traps to avoid. Avoid preemptively waiving your lien rights in a contract. I have seen some of these. A lot of times it will be an out-of-state contract. Big out-of-state developer or general contractor will have this kind of language in their 50-page contract that says basically you don't have lien rights as a subcontractor or as a contractor. And you want to avoid preemptively waiving lien rights. I doubt that it's legal under Oregon law, but you don't even want to go there. Just strike that provision out and say, no, we're not going to waive our right to have a lien under Oregon law. It's, I think, just easier to avoid that argument by not agreeing to that kind of a provision. Also avoid filing what they call a non-segregable lien. And so I gave some examples of an exhibit that you would attach to a lien where you kind of break down the difference between labor, materials, equipment, and services charged to a project. The reason that you want to do that is because you need to be able to segregate what the different portions of the lien are. So like I was saying, basically, you don't want to just list the total amount due without any detail anywhere. And the lien needs to include enough information that an owner can look at it and determine what the lienable charges are by asking simple questions. Avoiding problems with the lien notices. Just want to make sure that you deliver the notices to the right parties within the right time frame. So that's your 20 days. Within 20 days of lien filing, you notify the owner and the mortgagee. And at least 10 days before you file the lien foreclosure lawsuit, you want to send that notice of intent to file the foreclosure lawsuit. Again, those notices can be combined into one, and that way you get it out of the way first. Another trap to avoid is making sure that you're responding to all requests for information. There are different requests under the law that the owner can make, such as after the lien is filed, they'll send you a request for information. You have to respond within 15 days. And I'm sorry, that's actually a pre-lien request for information about kind of what's being done at the project and what's being charged, and then a post-lien request for information after they actually receive that notice of lien from you. You may get a request from the owner that says you got to respond within 5 days, and that's not 5 business days. So you could get it on, you know, a Thursday, and you want to make sure that you've responded by Monday. The reason to respond to those statutory requests for information is that it preserves your right to attorney fees. And if you don't provide follow-up with more information about the lien as requested, then you may lose your right to attorney fees. That's another reason that I suggest that people put a good breakdown of the lienable charges actually in the lien document that's filed, because then you can always point to that and say, look, there's plenty of information in the lien here, kind of as a fallback position. So basically, if you get one of those notices, you may want to talk to an attorney and just, you know, right away so that you can determine how best to respond and when to respond. Another consideration is just the lien timing, 75 days from the earlier of the last day you provided labor, equipment, or materials, or 75 days from completion of construction. Like I said before, it applies to lien or bond claims. If you're not getting paid after 30 days, you probably want to think about filing, you know, a notice or a lien, bond notice or a lien. Because if you come close to the 75 days in the case of a lien, you don't want to accidentally miss your timing, right? You thought the crew was out there doing some type of new work, but they actually were doing repair work, and that was the last day that you've got marked down, and you just don't want to get into a timing fight if you can avoid it. So performing punch list, or what they call de minimis work, doesn't extend your 75 days. Performing change order work under the same contract may extend your lien rights, and you can basically revive them in some cases. So at a minimum, you want to make sure that you get a signed change order that's clearly incorporated into the original contract, so that you are able to show that you maintained or even revived your lien rights for that particular project. Okay, finally, the right way to exchange a release for a check. Basically, don't sign your rights away except to the extent of payment, right? So we're happy to sign away lien rights to the extent that we've actually been paid and the check has hit the bank. So owner's viewpoint, they're concerned that the work is done, properly and timely completed. Owners want to know that they're not going to pay twice for the same work. On the other hand, the contractor wants to get paid. They want to preserve pending and potential claims if they're getting progress payments. They want to make sure that their subs and suppliers don't lien the project too. Similarly, subs want to get paid, preserve pending and potential claims. So probably be presented with a conditional and unconditional lien release by the owner of the project, or they may ask you for one. Basically, a conditional lien release is what you use before you get paid, and it's only effective once you actually get paid. An unconditional release releases your rights unconditionally and is effective immediately whether you actually have been paid or not. So conditional is before payment, unconditional once you're done and the check has hit the bank, then yes, you can unconditionally release up to the amount that you've been paid. A lien release from the contractor's perspective should be as narrow as possible. On the left-hand side here, I've got a sample broad release. I would say proceed with caution if you see someone trying to get you to release all claims up through a particular date, right? Better for a contractor is on the right, where the contractor will release rights and claims to the extent of the progress payment received for, X amount. And then you can even add a caveat here: expressly retains and does not waive rights or claims as to any of the following. And then that's where you would list, if you've got a claim pending on a project, we just list it on the release. That way everybody knows, okay, after we're done here, we've got a dispute about this issue and it's preserved. We will, get through the project and deal with that dispute at the end. Finally, last piece of advice would be on a lien release, review each progress payment release, even if they're using a standard form. We've seen some big projects where, say it's a 24-month job, they've been using the same lien release form for 22 or 23 months. Suddenly, there's a claim brewing among different subcontractors and contractors, and everybody wants to change the lien release. So you just got to watch out and make sure that, the standard release that you may have been signing throughout the project hasn't suddenly been changed, where it's suddenly is like more onerous. I've just seen it happen a few times where, not to call people out, but sometimes general contractors will do this to their subcontractors and just try to make a broader release of claims than previously existed. And that's just something to watch out for. And again, you just say, hey, let's go back to our standard release. Let's list the exceptions to the release for the claims that we know are pending on this project, and move forward, get the work done. And then you can have that preserve your rights for any payment dispute. So that is what I've got. If there are any questions.
Well, first of all, you were incredible as always. So thank you so much, Andrew. I really do appreciate it. We do have a couple of questions that came through. The first one says, can I file a mechanics lien in Oregon without a written contract?
Obviously, it depends on the facts and circumstances. But generally, if a contract is required for a particular construction project, then no. You wouldn't have
perfect.
Right under the construction lien law statute. There are a number of different types of liens, but I'm just talking about construction liens today.
Okay, thank you. All right, and then the next question, it says, if you miss the 8-day deadline to send the right to lien, can you still send it, but it will only look back to the previous 8 days of work?
That is exactly how we've used it. Yeah, if you're midway through the project and realize, oh, this is required, I haven't sent it, good practice to go ahead and just send it, knowing that that it only protects 8 days back, but that's kind of, that may be your hook to getting paid for the whole thing, because you still do have that lien right for at least part of it.
Right. Right, and it might just help as a collections tool, if nothing else. All right, and then the next question that came through is for the request for response within, that you have to respond within 5 calendar days for the information. Does that 5 days start when the request is received?
Not having the statute in front of me, I believe it may start when the request is sent. And because it's kind of tricky. It's not real clear how the request needs to be sent. It basically, that 5-day request, I do remember the way the law reads is the request is made to the sender of the notice. So the person that provided the notice that the lien has been filed, the one that receives it. So it's not necessarily the contractor, whoever sent the notice.
Right. Okay. All right. Well, we will have to look into that further. Thank you so much for that. And then there is one additional question that has come through. It says, is there a clause that I should add to my contract that will protect me from tariff increases?
We've worked those up for some people, and it's just kind of a modified escalation clause. It depends on each contract. What we have done is kind of a 2-tiered approach for like buyout timing, where it's, we all agree, here's the list of things, materials and subcontractors that are going to be bought out within the next 30 days, and here's the list within the next 60 days, for example. And so you can kind of assign risks inside and outside of that buyout period. So it's basically a modified escalation clause of, you can just structure it kind of however you want, but
Right.
as to timing and also as to percentages, depending on, if costs increase above 10%, that falls on the owner, but below 10%, that is absorbed by the GC through a contingency. And there's many ways to do it, but it's definitely an issue to watch out for.
Okay, thank you very much for that. All right, I do think that is all the questions that have come through at this time. If anybody does think of a question that wasn't addressed, please feel free to reach out and I'll be sure to answer any questions that come through. Can you go to the next slide for me, please? All right, here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan this QR code to access these incredible resources. Each state is unique in what documents and deadlines that it requires. So please, if you're working in a nearby state, whether it's Washington, Idaho, wherever it happens to be, please make sure you're checking it out to see what is required in that state, what those deadlines are, so that way you're protected and making sure that you are staying ahead of the game. There is a project information sheet that's wonderful to use. It's better to get some of this information early on in your project before there's any kind of a payment dispute. So asking the right questions is key. So go ahead and check out that information to help you guys out. The next slide, please. All right, our next webinar with Andrew is going to be September 10th. That's a Wednesday. What happens after I record my lien? How do I get paid? So please sign up for free at sunraynotice.com/education. We'd love to see you guys there. And then the next slide, please. All right, if you don't mind, give us a review on Google. We really do appreciate it. It takes about a minute of your time, but it helps us with getting some of that feedback and knowing what we can do to improve ourselves and our webinars and some of the content that you're looking for. So please check it out and give us that review. I'd really appreciate it. And then the next slide, if you don't mind. All right, and that is all we have for you guys today. Thank you so much to everybody who attended. We hope to see you at our next webinar. Andrew, you really were incredible. I do appreciate your time. I hope you all have a beautiful and wonderful sunny day. Thank you, guys.